In case we have never met, I'm Michael Price, and I want to help you succeed in growing your business.
Welcome, I'm Michael Price, your host.
And I'm Nancy, your co-host.
Usually when we talk about a pay raise, it's a cause for celebration. It's straightforward. You worked hard. Here's more money. Dinner's on you tonight. But I was looking at this latest announcement from the Department of Labor regarding federal contractors, and I have to admit my head started spinning about 2 paragraphs in. It feels less like a pay raise and more like a logic puzzle.
That is probably the most accurate description of federal compliance I've heard in a long time. It is a puzzle. And you're right. On the surface, the headline is simple. Minimum wage for federal contractors increases effective January 1st, 2025. But when you peel back the layers, you realize we aren't just talking about one number. We are talking about a fractured landscape where your location, your contract date, and even specific court rulings determine what you owe a worker.
Exactly. I saw 2 different numbers floating around. One is $17.75 an hour and the other is $13.30 an hour. And my first thought was, how can there be 2 federal minimum wages? Isn't the whole point of federal that it applies to everyone equally?
In an ideal world, perhaps. But here we are dealing with the ghosts of executive orders past and present. This is the core of the confusion. We have 2 competing mandates running parallel to each other. You have Executive Order 14026, let's call that the new rule, which was signed by President Biden. That's the one pushing the rate up to $17.75. But then you have Executive Order 13658, the old rule, originally signed by President Obama, which is only rising to $13.30.
Okay, so we have a new rule and an old rule. Why hasn't the new rule just eaten the old rule? Why is the $13.30 rate even relevant anymore if the Biden administration wants everyone at $17.75?
That is the multi-million-dollar question. And the answer, as it often is, lies in the courtrooms. See, the Biden administration intended for EO 13026 to cover essentially everyone. It was supposed to be the new standard, but several states sued to block it. We saw significant litigation in Texas, Louisiana, and Mississippi. The courts issued injunctions saying, hold on, you can't enforce this higher rate here.
Ah, I see. So the old rule of the $13.30 rate is basically the fallback mechanism?
Precisely. It's the safety net. Because those courts blocked the new rule, the Department of Labor can't enforce the $17.75 rate in those specific jurisdictions or for those specific types of contracts. So instead of falling all the way back to the statutory federal minimum wage, which is still stuck at $7.25, they fall back to the previous executive order, which is inflation adjusted annually, hence $13.30.
That creates a bizarre map for HR managers, doesn't it? I mean, imagine you're a large defense contractor or a tech services firm. You might have employees in California getting the $17.75 rate and employees doing the exact same job in Texas potentially stuck at $13.30.
It's worse than just geography. It's also about the timeline of the contract. The higher rate, EO 14026, generally applies to contracts that were entered into, renewed, or extended on or after January 30th, 2022. But if you are sitting on an old contract that hasn't been touched since 2021, you might still be under the old rule framework until you sign a modification. So, a compliance officer has to look at a map and a calendar and a legal docket just to cut a paycheck.
That sounds like a nightmare. Let's dig into the numbers a bit more because these aren't insignificant hikes. $17.75 is a decent jump. How does that compare to what we saw last year?
It is a solid increase. It's based on the Consumer Price Index, specifically for urban wage earners and clerical workers, so it's tracking with inflation. The jump to $17.75 is roughly a 2.5% to 3% increase over the previous year. It keeps purchasing power relatively stable. But for the businesses operating on thin margins, think janitorial services, security, cafeteria workers on military bases, that extra dollar amount per hour multiplied by hundreds of employees changes the bid math significantly.
And speaking of cafeteria workers, we have to talk about tipped employees. I noticed the Department of Labor didn't forget them in this announcement. But again, it looked like there were 2 different sets of rules.
You didn't miss that. And this is where the philosophy of the current administration really shines through. Under the new rule, EO 12026, they are effectively trying to kill the tip credit.
Kill the tip credit? Meaning they want tipped workers to earn the full minimum wage directly from the employer?
Exactly. For 2025, under the new rule, the cash wage for tipped workers is $15.98. That is incredibly close to the full $17.75. The gap is closing. The goal is to eventually have tipped workers earning the full minimum wage with tips being purely on top. But
Let me guess, the but is the old rule.
you're learning fast. Under the old rule, EO 13658, the cash wage for tipped workers is only rising to $9.30 an hour.
Wow, that is a massive delta. $15.98 versus $9.30.
Huge. That's nearly a $7 difference per hour for the same work, dependent entirely on which executive order governs your contract. If you are a federal contractor running a food service operation in a state where the new rule is blocked, your labor costs are drastically lower than a competitor in a state where the new rule applies.
It almost distorts the market, doesn't it? I mean, if I'm bidding on a federal contract and I can pay my workers significantly less because of a court injunction in my state, can I bid lower?
In theory, yes. Although government contracting officers are supposed to level the playing field, the reality is that labor costs drive pricing. But there is a trap here for the unwary employer. Just because you think you are in a safe state or on an old contract doesn't mean you are in the clear. The legal landscape is fluid. If an injunction gets lifted or if you modify that contract tomorrow, boom, you suddenly owe everyone $17.75.
And I assume the Department of Labor isn't just sending polite reminder cards about this. What happens if a contractor gets this wrong? Say they pay the $13.30 rate when they should have paid $17.75.
It gets ugly. First, you owe back wages. That's immediate. But the DOL doesn't like wage theft, even accidental wage theft. You could face debarment, meaning you are banned from federal contracting for 3 years. For a company that relies on government work, that is a death sentence.
So the strategy of ask for forgiveness later is a terrible idea here.
The worst. And remember, there is a notice requirement. You have to post these rates. You literally have to put a poster up in the break room or on the company intranet telling your employees, hey, this is what you should be getting paid. If you post the wrong poster, that's a violation too.
It's interesting to zoom out for a second. We are talking about federal contractors, but this group is huge. We aren't just talking about building fighter jets. We are talking about the people mowing the lawn at the VA hospital, the IT support guy at the Social Security office.
Roughly hundreds of thousands of workers, maybe more. The federal government is the largest purchaser of goods and services in the world. When they move the needle on wages, it ripples into the private sector. If the janitor at the federal courthouse is making $17.75, the private office building across the street has to compete with that to hire staff.
That's a great point. It's a soft power way of raising the minimum wage without actually passing a law through Congress to raise the national minimum wage.
Precisely. Congress hasn't touched the federal minimum wage of $7.25 in over a decade. It's fossilized. So the executive branch uses procurement power, these executive orders, to set a living wage standard where they can. It's a policy workaround. But because it's a workaround, we get this messy, bifurcated system of old rules versus new rules and court battles.
It feels like we are in a transition period that just won't end. Do you see this resolving anytime soon? Will we ever just have one number again?
It depends on the Supreme Court, honestly. The challenges to the president's authority to set these wages are working their way up. Some courts have argued that the Procurement Act doesn't give the president the power to just dictate social policy like wages. If the Supreme Court eventually says, no, the president can't do this, then both of these executive orders could theoretically collapse. Or conversely, they could uphold the new rule, and the old rule finally disappears.
Until then, we are stuck with the spreadsheet from hell.
And the map. Don't forget the map. If you are an employer, my advice is do not assume. Do not assume that because you are in Texas you are safe, or because you are in New York you are paying enough. Check the specific solicitation clauses in your contract. Look for the code 52.22.
5222 sounds like the secret code to avoiding a lawsuit.
It basically is. It's the clause that tells you which wage determination applies. And keep an eye on January 1st. These rates are automatic. You don't get a letter in the mail telling you to update your payroll software. You just have to know.
That's the scary part. Silence isn't permission. Silence is just the sound of you accumulating back pay liability.
Beautifully put. And remember, this applies to subcontractors too. If you hire a cleaning crew to handle your federal contract site, you are responsible for ensuring they are getting paid the right rate. It flows down.
So the responsibility is contagious.
Everything in federal contracting is contagious.
Well, on that cheerful note, it seems like the takeaway here is vigilance. The numbers are $17.75 and $13.30. They kick in on New Year's Day 2025. And if you're guessing which one applies to you, you're already doing it wrong.
Consult legal counsel, consult your HR director, and read the fine print. The cost of compliance is high, but the cost of non-compliance is your business.
A sobering thought for the new year. We'll leave it there. Thanks for guiding us through the maze.
Always a pleasure to decode the bureaucracy.
And for everyone listening, check those contracts. We'll catch you next time.
Bye for
A
now.
special thank you to MarketUS.com for furnishing us this information. You can reach them at MarketUS.com or call them at 954-636-3232. Before we go, this deep dive was created by the MarketUS.com team. Let us know your thoughts in the comments below. It's right below the subscribe link.
If you found this video helpful, please consider donating to helpallvets.org. Thank you.